Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer program. The Curious Lawyer is a fun, educational, entertaining walk down different areas of law that you may not be involved in every day. This is not your technical how to draft a tax plan or an estate plan or how to register a copyright, the day-to-day stuff that you have to do, the nuts and bolts stuff. That's not what we're doing here. This is fun, educational, and entertaining ways to look at different areas of the law that you don't normally see or deal with, but which intersect our lives and are fun, interesting, engaging, and hopefully educate you and broaden your horizons. And so we've done programs on sex law, CIA law, celebrity and paparazzi law, dog law, everything you ever wanted to know about dogs, the music of U2 as a means to explore copyright. So all these fun educational ways are there for us to explore different areas of the law. Well, today's program, of course, is our Bill of Rights series at the Curious Lawyer. And the Bill of Rights series is focused on the first 10 amendments, obviously, with a 1-hour program for each of the amendments. And we are rolling those out for you to allow you to go back and reinvestigate those many amendments that perhaps you never learned about in law school, perhaps you never deal with or address in your practice. Some are focused on criminal areas, some on civil. But all of them are amendments that at a cocktail party it may come up to find out what it's about. Well, now you will know. So today we're on the 8th Amendment, and let's start by looking at the text of the 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The issues we're going to address today, looking at the 8th Amendment, specifically involve what is the substantive nature of the 8th Amendment? What's the historical scope and rationale for it? What's the purpose? What's the goals that the 8th Amendment is animating and driving us towards? Specifically, we're going to look at death penalty punishments and, of course, the nature of the death penalty within the 8th Amendment. We're going to look at solitary confinement as a punishment. We're going to look at the 3 strikes laws and punishments that follow from 3 strikes life sentences imposed. We're going to look at excessive bail also. And in all of this, of course, we're going to look at SCOTUS, the U.S. Supreme Court, and how it's dealt with many of these issues and cases and where it stands currently today on many of these issues. So let's get rolling, and let's start again, though. Let's just quickly pause at the 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. There's barely 24 words there, yet it can spawn hundreds and hundreds of cases and massively complex litigation, which we're going to dive into now. So let's start with the history. 1689, in England adopts a Bill of Rights, and it prohibited cruel and unusual punishments. That is not a typo. That was the Old English way of spelling. So by 1776, George Mason included a prohibition of cruel and unusual punishments in the Declaration of Rights that he drafted for the Commonwealth of Virginia. At the constitutional debates, opponents of the Constitution feared that this new power would allow Congress to use cruel punishments as a tool to oppress people. And so here we have a quote from Patrick Henry. Congress may introduce the practice of France, Spain, and Germany of torturing to extort a confession of the crime. They will tell you that there is such a necessity of strengthening the arm of government that they must extort confession by torture in order to punish with still more relentless severity. We are then lost and undone. Abraham Holmes argued that the Congress might repeal the abuses of that diabolical institution, the Inquisition, and start imposing torture on those convicted of federal crimes. And this is his quote, "They are nowhere restrained from inventing the most cruel and unheard of punishments and annexing them to crimes, and there is no constitutional check on them, but that racks and gibbets may be amongst the most mild instruments of their discipline." So of course, as you see on our next slide here, from the debates, the focus was on really barbaric methods of hurting people, inflicting punishments, and a fear of the government using torturous methods to extract confessions in order to put people in prison, punish them, and have a more powerful centralized government. And so that fear led to these debates about what kind of a check do we need on government. And so in 1791, the same prohibition from England became the central component of the 8th Amendment to our Constitution. This then raises questions for us today that we will explore today. What standards do we use? Do we use the standards of 1791 as to what was cruel and unusual then, or do we look at what's cruel and unusual by our modern contemporary standards? If we are looking at modern contemporary standards, whose modern and contemporary standards? Is it the court's own moral judgment? Is it some broader sense of where the public is today? And of course, we will also look at proportionality in this, in terms of the relationship between the punishment and the crime, and if there is and should be some sort of proportionality requirement. So let's get rolling and start with, who does this apply to? Does it apply to the states? Does it only apply in federal criminal court to federal courts? In other words, has the Eighth Amendment been incorporated and applied to the states through the 14th Amendment? And so let's quickly stop and pause, and if you remember from law school, if not, good for you, this is your first time out, we're going to talk about the incorporation doctrine. And so the protections of the constitutional amendments, the first 10 that we're focused on here, only applied to the federal government, but not state governments. And so the question is whether, after the adoption of the 14th Amendment and its due process clause, the first 10 amendments to the Bill of Rights were then incorporated through the 14th Amendment and made applicable to the states as a check on state power too. And so the basic test is here, you see quoted on our slide, and that is that fundamental rights rooted in the tradition and conscience of our people, and thus implicit in the concept of ordered liberty, are applied to the states via the 14th Amendment. And that's from the Griswold case in the 1960s, reported at 381 U.S. 499. And by this point, really all but a couple of issues coming out of the first 10 amendments have been applied to the states. And so here, as we stand today, the cruel and unusual component and the excessive fines clause of the Eighth Amendment do apply to the states. But what's most interesting is this is not necessarily old law or well established. We can go to 2019 for one of the most recent words of the U.S. Supreme Court on the incorporation doctrine. And so we'll look here at Timms versus Indiana. This is from 2019. And this was a civil forfeiture case. And so what basically happened is Tyson Timms was arrested on drug and conspiracy to commit theft charges. They confiscated his Land Rover. He had bought it for 42 grand. And the value of the Land Rover at 42 grand was 4 times more than the maximum fine that Indiana law allowed for his punishment, which was a $10,000 fine. And so he was obviously unhappy that his Land Rover had been confiscated. But the Indiana Supreme Court held that the Eighth Amendment was not enforceable to the states, and therefore that state forfeiture couldn't violate the Eighth Amendment. And so this squarely then raised the issue of, does the Eighth Amendment apply to the states in terms of the excessive fines prohibition? And went to the U.S. Supreme Court, and in 2019, SCOTUS held that the 14th Amendment due process clause does incorporate this part of the Eighth Amendment and apply it to the states. And so there you go. It's incorporated and applied to the states. So let's get started here, and we're going to have a bit of a timeline walk through various issues and cases. And we're going to start really by looking at what SCOTUS has done dealing with the cruel and unusual, and then we're going to go into the death penalty actual cases and the shifting sands on death penalty over time. But let's start here in 1910 on our first bullet point. The Supreme Court then acknowledged that what constitutes a cruel and unusual punishment has not been exactly decided, and that's the Weems versus U.S. case, 217 U.S. 349 from 1910. In 1947, the Supreme Court found that whether a state can put a condemned man on an electric chair a second time after sending a non-lethal bolt of electricity through him the first time, they had to address whether that was cruel and unusual. And what the majority held, that the cruelty of the punishment at issue should not be measured by what happened in the past or the mental anguish the prisoner might feel as he awaits his second date with a chair. On the other hand, the 4 dissenters contended that the sequence of events was relevant and that no one would doubt that a punishment that consisted of 2 jolts of electricity weeks apart would be cruel. That was 1947. So by 1958, Chief Justice Earl Warren wrote in the Trop versus Dulles case, and this is not a death penalty case, but what he wrote is that the Eighth Amendment's cruel and unusual punishment clause has to quote, draw its meaning from the evolving standards of decency that mark the progress of a maturing society, end quote. There the case was dealing with a World War II soldier who had deserted for a day after being sentenced to stockades. He was, came back after a day, made a mistake, but he did desert. He was court-martialed, and he got 3 years of hard labor. And post-sentence, he went to seek a passport so he could travel, and that was denied because of a Civil War-era statute that stripped citizenship of those who were deserters in the time of war. It went up to SCOTUS, and SCOTUS held that under this evolving standard of a maturing society to gauge what's cruel and unusual, denying him his passport and stripping him of that was unconstitutional. So that evolving moral sense of decency standard that we get from 1958 has become then the benchmark. And so by 1972, the U.S. Supreme Court held that the death penalty was unconstitutional, and it voided 40 state statutes and 629 convictions, sending everything back to the states to really start again and redraft their statutes in terms of death penalty. And so what SCOTUS held in Furman v. Georgia is that cruel and unusual existed where it was too severe for the crime, arbitrary, or offended society's sense of justice. And that required states to more narrowly focus in on the bases and litmus tests for when death penalty would be issued. In 1972 then, death penalty is unconstitutional. By 1976, the U.S. Supreme Court reinstates the death penalty in Gregg versus Georgia and starts affirming new state laws allowing for the death penalty. And so this is going to take us to our next slide to look at the death penalty regime from the late 70s on. So in 1977, the Supreme Court found that the death penalty was improper for the rape of an adult woman. That's Coker versus Georgia, 433 U.S. 584, 1977, and it was 6-3 as a decision. And I'm going to note here, actually, the splits in the cases all the time, because it goes to show how contentious an area of law this is and how significant it is in terms of the shifting makeup of the court can massively shift how a case comes down. Now, in 1982, the Supreme Court held that the death penalty was improper for felony murder where the defendant didn't do the murder or intend to kill, and this was an accomplice driver case. That was a 5-4 decision. A little later in the 1980s, in 1989, again, a 5-4 decision, the Supreme Court held that it was not cruel and unusual to execute offenders who were at or above 16 years of age at the time of their crime. And the Supreme Court looked at objective data on crime and crime rates to discern what modern societal thinking meant as we looked at this. And again, that goes to show how the court is filling in this idea of what is our current standard and where you look to figure it out. In 2002, in a 6-3 decision, the court held that it was cruel and unusual to execute the mentally ill. And there it was a defendant who was, quote, mildly mentally retarded, end quote, with an IQ of 59, and that's a 2002 case again. In 2005, the issue of whether it was cruel and unusual to execute a prisoner for a crime he committed when he was a minor was at issue. And the court cited a variety of recent social science and scientific evidence to conclude that the execution of people who were minors at the time of their crime did violate our evolving standards of decency, and hence it violated the Eighth Amendment. That too, though, 2005 case was 5-4. In 2008, another 5-4 decision. This is coming out of Kentucky, and a Kentucky law that allowed the death penalty for the rape of a child where the child was not killed. And that was held unconstitutional 5-4 in 2008. So this brings us to 2022. We're going to take a look at the U.S. Supreme Court's one of its more recent opinions. This is Shin versus Ramirez. And here are the facts. Ramirez was convicted on 2 counts of first-degree murder for the 1989 stabbing deaths of his girlfriend and her 15-year-old daughter, as well as the rape of the child victim. Ramirez lost his appeals, and he eventually filed a federal habeas case claiming that his trial lawyer in the state criminal courts didn't put on evidence of how he had an intellectual disability. He was kind of like that case we just looked at, was mentally ill and had mild mental retardation, perhaps. And he had a history of being abused as a child, and those were the issues that should have, raised the issues about his mental state. So the issue is whether this convicted death penalty offender could present this new evidence of the ineffective assistance of counsel during his prior appeals in order to show that they had missed the boat, in other words, and that they had missed this massive issue that should have gone to whether he could get the death penalty. Well, the federalism rule is as follows, and this was the quote. From the beginning of our country, criminal law enforcement has been primarily responsible of the states. Because federal habeas review overrides the state's core power to enforce criminal law, It intrudes on state sovereignty to a degree matched by few exercises of federal judicial authority. And so that federalism balance was very important for the Supreme Court in looking at whether they could tell a state they did it wrong. And so in a 6-3 decision, the Supreme Court held that even if a state appellate lawyer failed to raise proper issues in the original state court appeals and was indeed ineffective, it binds the defendant and he cannot raise them in federal court on federal habeas review. Quote, a prisoner bears the risk in federal habeas for all attorney errors made in the course of the representation, end quote. 6-3, the dissenting 3 there said, quote, this decision is perverse, it is illogical, end quote. So that risk of lawyer error means that the death penalty stood for Mr. Ramirez in that case. Let's keep going and look now and step back a little bit and talk about this evolving standards approach to understand what it is as we figure out what are our modern societal norms. Death penalty is constitutional in some cases for certain crimes and methods of execution subject to challenge under this test. The originalist approach, we can see a plurality in 2008 that rejected the evolving standards approach. And so here you can see in 2008 we have 4 Supreme Court justices in the Bays versus Rees case that really said we need to get away from that evolving standards approach of Justice Warren and the Warren Court and go back to an originalist approach. And so under this, the method of execution challenge requires basically substantial or objectively intolerable risks given alternative methods. Only punishments that add super levels of pain beyond what is necessary to effect a death sentence would ever fail. Let's look now in our next slide at Justice Blackmun's famous last dissent. And this sort of comes on, and we're going to see Justice Blackmun speak in a couple minutes here in terms of his experience on the court over multiple decades dealing with death penalty cases. But here we have his quote. Despite the effort of the states and courts to devise legal formulas and procedural rules to meet this daunting challenge, the death penalty remains fraught with arbitrariness, discrimination, caprice, and mistake. Reasonable consistency, on the other hand, requires that the death penalty be inflicted even-handedly, in accordance with reason and objective standards rather than by whim, caprice, or prejudice. Finally, because human error is inevitable and because our criminal justice system is less than perfect, searching appellate review of death sentences and their underlying convictions is a prerequisite to a constitutional death penalty scheme. From this day forward, I no longer shall tinker with the machinery of death. For more than 20 years I have endeavored, indeed I have struggled, along with the majority of this court, to develop procedural and substantive rules that will lend more than the appearance of fairness to the death penalty endeavor. Rather than continue to coddle the court's delusion that the desired level of fairness has been achieved and the need for regulation eviscerated, I feel morally and intellectually obligated simply to concede that the death penalty experiment has failed. The problem is that the inevitability of factual, legal, and moral error gives us a system that we know must wrongly kill some defendants, a system that fails to deliver the fair, consistent, and reliable sentences of death required by the Constitution. So that was Justice Blackmun's, really what is known as his famous last dissent in the death penalty cases from 1994, where he came down and explained, as you saw there in those very moving words, for him at least, in terms of how he had come to deal with the death penalty cases in his career. And so let's, on this next slide, watch this 2-minute slide of Justice Blackmun speaking, which kind of contextualizes the death penalty and how the death penalty has worked, at least for him and for the Supreme Court, before we move on shortly to solitary confinement. So here is Justice Blackmun speaking.
I wanted to ask you about a case that was very difficult for you, that term, Furman versus Georgia, which declared the death penalty unconstitutional.
I guess I was willing at that time to rely somewhat on legislative judgment, and if the states wanted it this way through the expressions of their legislatures, why they were entitled to have it that way. But finally, of course, in the Collins case a year or so ago, I still felt the same, but looked at it from the point of application of the death penalty and felt that it could not be administered and applied in line with the equal protection and due process clauses.
Do you think at the time you had more faith in the fair administration of the death penalty?
Yes, at least to the extent of letting the states have a try at it, and that was obviously a mistaken position to take, because in later years I was convinced that they couldn't rationally apply it.
Well, when Furman versus Georgia was decided, you had probably only heard 3 or 4 death penalty cases, but by the time you wrote in Callens, you had voted on hundreds. Do you think that experience made a difference?
Oh yes, I'm sure it did. It is true that we were just in the beginning of the death penalty issue at the time Furman came down. How I would vote in that case today, of course, is an interesting question.
There you had Justice Blackmun. Now we are going to look at some Supreme Court interpretations, and we're going to shift from the death penalty to solitary confinement. And the U.S. Supreme Court has held that the Eighth Amendment can put limits in terms of, through the cruel and unusual clause, that apply to conditions of prison, conditions of conviction for convicted prisoners. And those exist when number one, the action is objectively serious, and number two, the prison is deliberately indifferent to the harm of its action on the prisoner. And so the question we are now going to look at here is, how does solitary confinement fit into this structure? If a prisoner is lawfully convicted and gets a sentence of a certain term, and then once placed in the prison is placed into then solitary confinement, the question then is that a violation of the cruel and unusual punishment clause as applied to the prisoner? And we look at this by looking at whether the action was objectively serious and whether the prison was being deliberately indifferent in terms of the harm of its action on the prisoner. And there's a circuit split, it turns out, here, and we're going to look on the next slide at how this circuit split has basically shaken out. 5 circuits have held that solitary confinement can be cruel and unusual depending upon the facts and the circumstances, and 3 circuits have said it's not. And so we have the 2nd, the 3rd, the 4th, the 7th, and the 11th circuits, all of whom have held that it's not cruel and unusual. But in the 6th, the 9th, and the 10th circuits, they've held that it can be cruel and unusual. Now, let's take a look here at an old Supreme Court case, because we're going to get shortly to a modern case that's pending before the U.S. Supreme Court looking at solitary confinement. But let's start by looking at this old case. And here we have a sense, honestly, of how the founding generation of this republic viewed solitary confinement. And in re Medley, reported at 134 U.S. 160, at page 170, and this is from 1890, the U.S. Supreme Court said that an additional punishment of such a severe kind that it is spoken of as, quote, a further terror and peculiar mark of infamy to be added to the punishment of death. And in that case, it was dealing with a solitary confinement of 4 weeks, as the Medley court addressed it. And that was sort of its words in terms of how we look at solitary confinement. So now let's look at a case in 2022 of a man who has spent 26 years in solitary confinement. And this is the case of Dennis Wayne Hope. He's been in solitary confinement for 26 years in a cell about the size of a compact car. He's allowed out for 1 to 2 hours per day to exercise in an exercise yard that's about the size of 4 compact cars. His only human contact is with guards who strip search him and handcuff him during that process. And these decades of isolation have led to hallucinations, chronic pain, and suicide ideations. And so the question is whether that sort of treatment of that long in solitary confinement is itself cruel and unusual punishment, and it has to be ceased and terminated in terms of being confined in that way. This case, as you see here, went up to the 5th Circuit, and the 5th Circuit held that solitary confinement here doesn't offend the 8th Amendment, including the length here. And so this case now has gone to the U.S. Supreme Court with a cert petition pending as of March 2022. And you can go to the Supreme Court's docket. You see there the link, because by the time you're watching this program, the cert petition may have been decided. Maybe it's being granted. Maybe it's being denied. If it's granted, then there'll be a supplement to this program that you can watch later, or you can follow it up yourself. But when that case comes down, you'll have a context, having watched this program. What's really interesting to see here is if the Supreme Court takes it, how our current Supreme Court, with the recent appointments by President Trump, will address this issue, and how it will look at solitary confinement within the Eighth Amendment, and whether the Supreme Court will hew to an evolving standards, or whether it will be another area that the current Supreme Court makeup looks to shift the nature of the Warren Court precedents in terms of how the Supreme Court goes about doing its business, and does it go back to more of an originalist approach? And under either approach, how will it look at solitary confinement, given that old U.S. Supreme Court case we saw, which talked about the founders' really horrors in terms of their perception of solitary confinement and what a brutal punishment it was for the mind. So that case is pending, and we will see what happens to Mr. Hope there. Now let's shift to three strikes laws. And these have been in the press for the last 20, 30, 40, 50 years. So we will do an overview of the three strikes laws in different states. We'll look at a couple in particular, and we'll see applications of the Eighth Amendment's cruel and unusual punishment clause to people who receive significant, term or life sentences for a third strike in a third strike jurisdiction. Let's start this program, however, on this point in the 1990s. And there was a large new wave of state and also federal laws known as three strikes laws that basically held that if you have a third strike that was a violent felony, then the defendant can get 25 to life for that third strike. But it's a lot broader than that. So let's take a look at this clip for the next several minutes that gives you a deep background on the policy issues that were animating the people in different states and jurisdictions to push for these types of laws. And so here we go.
The nation, not just California, was shocked. It was a shocking crime. And it emboldened a lot of people who had sort of given up hope of changing things.
The law passed in California by a wide margin, and by 1996, the three strikes wildfire had spread to 24 states and the federal government.
This was an angry era in American criminal justice.
Crime scholar Frank Zimring says Americans were angry because despite having put a record number of people in prison, crime still seemed out of control.
What was supposed to deliver people from their crime fears, what was supposed to reduce the homicide rate, was the imprisonment cure, and it hadn't worked. So that what happened in the 1990s is the transition from lock 'em up to throw away the key.
This is a third strike case.
While in most states, all three strikes had to be violent or serious crimes, in California, the third strike was unique.
What made it unique was that you commit any kind of a crime, the lowliest crime, that made you eligible for the three-strike law.
Los Angeles District Attorney Gil Garcetti had originally opposed that idea, believing it would put too many low-level offenders in prison for life.
It was going to be a waste of money. We know that after the age of 35 or so, crime drops off with men like this. So we're going to keep them till 50, 60, 70, 80 years of age. And even though I spoke out strongly, we were drowned out.
3 years into the law, at this Los Angeles Kmart, Kenneth Keel was arrested for shoplifting $100 worth of items.
I had became addicted to crack cocaine at about the age of 20, 21. I figured if I committed a petty crime, the most I could get would be a few months, couple of years in prison.
But Keel had a prior record, including robbing people at ATM machines.
I discovered that Gil Garcetti was the DA and he was pursuing third strike cases similar to mine. And that's when I realized that this is serious business.
I'm an elected official, and the voters told me this is what they want.
Prosecutors and judges had some discretion in deciding whether to apply the law, and Garcetti had become a vigorous enforcer. Keel was convicted and received a sentence of 25 years to life. 10 years after the law was enacted, the data was stark. Nearly half of the three strikes inmates were serving 25 to life sentences for non-violent crimes.
This law, I think, did not do what the voters intended. It completely overreached and resulted in judges having to mete out sentences that were disproportionate to the criminal conduct.
So let's take a look. Having seen that, you understand the framework of what was motivating legislators and people and police and district attorneys in terms of how they confronted these problems, how they then sought to address them, and then some of the fallout that came from it in terms of whether it worked. But let's start, of course, with the Supreme Court, and we're going to go back in time a little bit before the 1990s to the 1960s, because three-strike type laws weren't a product of the 1990s, even though they came to the forefront really in the 1990s. But we can go back to the 1960s for that. And so we're going to look here, and even earlier, but we're going to look here at the case of Rummel versus Estelle. And this is a 1960s case from the, or 1970s by the time it got to the U.S. Supreme Court, but the fact pattern starts in the 1960s with Mr. Rummel, and it's coming out of Texas. And so in 1964, Rummel pleads guilty to the fraudulent use of a credit card where he got $80 worth of goods or services. And because the amount in question was more than $50, under Texas law at the time, it was classified as a felony. Then, in 1969, Mr. Rummel pleads guilty to passing a forged check in the amount of $28.36. Forged check violations in Texas were also classified as felonies. So at this point, in 1969, Mr. Rummel and his kind of white-collar type, fraud type behavior has now got 2 felony strikes. And in 1973, as he rolls into a new decade, here you had the following facts. He refused to return $120.75 that he received as payment for repairs on an air conditioning unit, repairs he never performed. So basically, someone came along and he was, I guess, in the air conditioning repair business at that point. Someone paid $120. He refused to do the work or didn't do the work or whatever the reason was, and he didn't give the money back. That was deemed felony theft. As his third strike in the trial court in Texas, he got life. So let's listen for the next couple minutes to just part of the oral argument in the U.S. Supreme Court as this case worked its way up, because it went up through the Texas courts, which affirmed his life sentence. And here you can hear a fascinating exchange between his lawyer and some of the Supreme Court justices of the United States that sort of frame these issues in the background and what was going on. And then after you listen to that, we're going to get to the actual decision and what SCOTUS held. So here you go.
Mr. Atlas, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court, my name is Scott Atlas, Court-appointed counsel for Petitioner William James Rummel. The only issue before this Court is whether the Texas Habitual Offender Statute, which since 1856 has mandated an automatic life sentence upon third felony conviction, is cruel and unusual in violation of the Eighth Amendment to the United States Constitution as applied to the 3 offenses for which my client received his life sentence. The facts are simply stated. In 1964, at the age of 21, Rummel pleaded guilty to buying 4 tires at a gas station worth $80 with a credit card that wasn't his. In 1969, he pleaded guilty to forging a $28.36 check to pay rent at a hotel. And in 1972, he accepted a $120.75 check, promised to fix an air conditioner, didn't do it, and in 1973 a jury convicted him in essence of not intending to do it when he accepted the check. In the state trial court, after the conviction, the jury found that he had committed the 2 prior felonies and the judge assessed him the automatic life sentence required under Texas law.
All right, so there you heard that exchange. Now on the next slide, let's see what SCOTUS held. It was a 5-4 decision, and the Supreme Court held that a life sentence for obtaining the $120.75 by false pretenses imposed on a 3-time offender under Texas's recidivist statute was not cruel and unusual. And so there was a majority and a dissent, obviously, given it was 5-4. And so let's look at what the majority said, and then we're going to look at what the dissent said. This is the majority quote. In this case, however, we need not decide whether Texas could impose a life sentence upon Rummel merely for obtaining $120.75 by false pretenses. Had Rummel only committed that crime, under the law enacted by the Texas legislature, he could have been imprisoned for no more than 10 years. In fact, at the time that he obtained the $120.75 by false pretenses, he had already committed and had been imprisoned for 2 other felonies, crimes that Texas and other states felt were serious enough to warrant significant terms of imprisonment even in the absence of prior offenses. Thus, the interest of the state of Texas here is not simply that of making criminal the unlawful acquisition of another person's property. It is in addition the interest expressed in all recidivist statutes in dealing in a harsher manner with those who by repeated criminal acts have shown that they are simply incapable of conforming to the norms of society as established by its criminal law. So you see there some of the animating issues that the majority supported, which go back to sort of the way the oral argument was even framed and the way the policy debates are about these statutes in terms of why they're acceptable to give such harsh punishments on a third strike, because it's not just telescoping in on that third strike of $120 and getting life for stealing $120. It's life for stealing $120 as a third felony when you have a history and pattern of doing this and you don't seem to be able to control yourself and conform yourself, as they said, to the norms of society. Now that was the majority. Let's take a look at the dissent, the dissenting 4 in Rummel versus Estelle. Examination of the objective factors traditionally employed by the court to assess the proportionality of a sentence demonstrates that petitioner suffers a cruel and unusual punishment. Petitioner has been sentenced to the penultimate criminal penalty because he committed 3 offenses defrauding others of about $230. The nature of the crimes does not suggest that petitioner ever engaged in conduct that threatened another person, involved a trespass, or endangered in any way the peace of society. A comparison of the sentence petitioner received with the sentences provided by habitual offender statutes of other American jurisdictions demonstrates that only 2 other states authorize the same punishment. And so there, what the dissenters were focusing on was that it's nonviolent, it didn't harm people in a physical sense, it didn't involve breaking or trespassing into people's homes, and proportionality in a comparative sense to other jurisdictions, this was harsh and brutal because really no other American jurisdictions, maybe save one other, would allow someone to get a life sentence for a third nonviolent, fraudulent, financial type transaction crime. But that's the way it shook out for Mr. Rummel, and that was Rummel v. Estelle on cruel and unusual punishment for 3 strikes. So now we're going to come back to the 1990s, and we're going to start looking at some cases that start after California's 3 strikes law. We watched that clip earlier about the animating and motivating reasons for California to enact its 3 strikes laws, and there are other states that had similar ones. And some of these cases then coalesced and eventually worked their way up to the Supreme Court, which we'll see. We're going to start with California's case, and this is the case of Andrade versus Lockyer, 538 U.S. 63, 2003 is the ultimate SCOTUS reported citation. But here are the facts. Mr. Andrade was a 9-year Army veteran, and he stole some videotapes, VCR stuff from Kmart. He had prior convictions for petty theft, residential burglary, transportation of marijuana, and escape from prison. And because under California's version of 3 strikes, any felony third strike can trigger the third strike regime, that theft of videotapes from Kmart counted. So he then gets the life sentence on the third strike, and 25 to life sentence on the third strike, and that gets affirmed as it works its way up through the courts. It eventually gets to the Ninth Circuit in his challenge, under his habeas challenge to this prison sentence. And the case then eventually lands in the hands of Dean Erwin Chemerinsky, the dean of the, now dean of the Berkeley Law School, and who argued the case to the U.S. Supreme Court. And so let's watch here an exchange of Dean Chemerinsky in the U.S. Supreme Court in the early 2000s. And it's kind of an interesting juxtaposition to the exchange that we saw earlier from the U.S. Supreme Court in the Estelle case from the 1970s. And you see the tracking of the same issues going on just a couple generations later, perhaps. So let's listen to it.
The California Court of Appeals said the test under California law is whether the sentence, quote, shocks the conscience. That is a quite different test than the objective test of Solem and Harmelin, which is carefully calibrated at determining whether a sentence is grossly disproportionate. Also, the three factors used by the California Court of Appeal under the Lynch analysis were quite different than the Solem analysis. First, there was no comparison of the gravity of the offense to the harshness of the punishment. Second, the court did not look to similar punishments in the same jurisdiction. In California, the punishment for rape would have been 8 years in prison. The punishment for manslaughter would have been 11 years in prison. The punishment for second-degree murder would have been 15 years in prison. And he received 50 years to life. In fact, if his prior offenses had been rape and murder, he could have at most gotten a year in jail. This goes to Justice Stevens' question earlier. His crime here was the misdemeanor of shoplifting. Because of double counting, it was elevated first to petty theft with a prior, and then it triggered the three strikes law. But in order for it to be petty theft with a prior, there has to be a prior property offense. If his prior crimes had been rape and murder, then his maximum sentence for stealing his videotapes would have been a year in jail. It's because his prior offenses were property crimes that the double counting could occur. Additionally,
I thought your opponent, or perhaps representing the statement, said that was not so.
No, Your Honor. The confusion here is that with regard to petty theft, the misdemeanor, can become the wobbler petty theft with a prior under California Penal Code Section 666 only if the prior crime is a property crime. And if you look at California Penal Code Section 66, it enumerates just property crimes.
So there you heard it. And now let's look at what the Supreme Court held in these companion cases of Mr. Andrade, and the other companion case was Ewing versus Lockyer, 538 U.S. 11, 2003. And so this is what the Supreme Court of the United States held in the Andrade case, and it was the same in the Ewing case. They argued that these laws respond to widespread public concerns about crime by targeting the class of offenders who pose the greatest threat to public safety, career criminals. It is enough that the state of California has a reasonable basis for believing that dramatically enhanced sentences for habitual felons advances the goals of its criminal justice system in any substantial way. Thus, the statute was a rational legislative judgment to deal with repeat offenders, and as the Supreme Court held, it was not cruel and unusual. Now, the dissent argued that proportionality has to be applied in assessing sentences, and the absence of proportionality triggered a cruel and unusual violation. In other words, what the dissent argued is that giving someone a sentence of 25 to life for stealing videotapes from Kmart was disproportionate to the crime, even in conjunction with prior felonies of the kind that happened here, and that the totality has to be looked at within this proportionality lens. And if you don't use a proportionality lens and you focus on just the legitimate exercise of state police power to control habitual offenders, you end up with people who ultimately, because of their prior criminal history, then stealing videotapes from Kmart, getting a profound sentence. And that's where the policy debate is between majorities and dissents on the U.S. Supreme Court. That was how the U.S. Supreme Court came down, yet again, kind of like the Rummel case that we saw, hewing to that line. And there have been no newer cases on three strikes working their way up to the Supreme Court, but probably because these statutes have now, as you see, over multiple generations been repeatedly affirmed by the Supreme Court. Let's talk now briefly about the Supreme Court and excessive bail. That's the other part of the Eighth Amendment that we were looking at earlier. And we're going to now explore what does it mean in terms of the Eighth Amendment's excessive bail provisions. Well, so here's a general rule. Bail's permitted if it's set at a reasonable level calculated to protect government interests. That's Stack versus Boyle, 342 U.S. 1, 1951. And so remember, the Eighth Amendment says that excessive bail shall not be required nor excessive fines imposed. So there's a limitation on there not being excessive bail. And so, of course, bail is therefore permitted, but it can't be permitted at a level so long as that level is reasonably calculated to protect government interests. And so one of the questions this raises is civil forfeiture. When money is taken, an excessive fine is taken also, what does excessive fines language mean? And does money bail then, we're going to look at, violate the Eighth Amendment because ultimately it punishes poverty in some sense? Let's take a look at that. And this is now on the next slide, the question of forfeiture as violating the excessive fines clause of the Eighth Amendment. And so we're going to start by looking at the excessive fines clause of the Eighth Amendment before we move to the excessive bail component. But let's start and look at what happens when your money's taken if you get convicted of something. So here we have the case of United States versus Bakajian, 524 U.S. 321 in 1998. And here are the facts. In 1993, the Syrian immigrant Hosep Bakajian and his family tried to fly from Los Angeles to Cyprus with $350,000 in their luggage, and it was apparently in order to pay a debt. The government sought to require that a criminal defendant charged with violating federal reporting requirements regarding the transportation of more than $10,000 in currency out of the country fundamentally then forfeit everything. So in other words, because he didn't report the fact that he was taking that much cash out of the country, and there's a reporting requirement if you take more than $10,000 cash out of the country, the government's position was that the entirety of his money should be forfeited. Now, he was then charged with failing to report, so he pled guilty to failing to report. The government forfeited the entirety of his money. He then appealed that, and here's what the court held. The forfeiture of his $357,000 violated the excessive fines clause because the amount forfeited was grossly disproportionate to the gravity of defendant's offense. In determining proportionality, the court did not limit itself to a comparison of the fine amount to the proven offense, but it also considered the particular facts of the case, the character of the defendant, and the harm caused by the offense. And here's Justice Thomas writing for the court. Comparing the gravity of respondent's crime, i.e. the failure to report taking more than $10,000, with the $357,000 forfeiture the government seeks, we conclude that such a forfeiture would be grossly disproportional to the gravity of his offense. It is larger than the $5,000 fine imposed by the district court by many orders of magnitude, and it bears no articulable correlation to any injury suffered by the government. So there you have an example of how the reporting requirements, if violated, can lead to punishments, $5,000 fine, $10,000 fine, $20,000 fine, whatever they may be. But to forfeit the entirety of your money would actually be an excessive fine that violates the Eighth Amendment and is unconstitutional. So from there, let's shift to the first part of the Eighth Amendment. Remember, excessive bail shall not be required. And let's take a look at the issue of money bail, which has been in the press a lot lately and is now becoming a larger and larger issue that's being batted around in different state courts and is working its way through the courts in Eighth Amendment litigation too. And so let's just start with a little bit of background because we're going to look here at California as an example in terms of how money bail has been working, at least in this state, as a microcosm of perhaps some other states where similar issues are happening. So here are some basic facts. Every year there's around 500,000 people who are eligible for bail, but they're unable to get it simply because of a lack of resources. That comes from Lauren Bennett's work called Punishing Poverty, Robinson and the Criminal Cash Bond System, published at 25 Washington and Lee, Journal of Civil Rights and Social Justice in 2018. And so that's kind of a background fact issue that kind of then animates what's going on in the money bail situation in terms of what you do when bail is set at a level that someone's eligible for bail because of the nature of their offense, but it's set at a level such that they have no means to achieve bail because they don't have economic resources. Well, here's a California Supreme Court case of In re Humphrey. It's reported at 482 Pacific 2nd, 1008, 2021. So it's a very recent decision. And it involved a 63-year-old man named Kenneth Humphrey. And Kenneth followed a 79-year-old man, Elmer, into Elmer's apartment in the senior home in which they were living. And Kenneth threatened Elmer, he threw his phone to the ground, he demanded money, and he stole some money and a bottle of cologne. And so the trial court, when Kenneth was arrested for his sort of elder crimes against his fellow elder home cohabitant, the trial court sets a $600,000 money bail and didn't consider in the calculus Mr. Humphrey's inability to come up with $600,000. And so what the California Supreme Court held is that these regimes where ability to pay is not considered are indeed unconstitutional because ability to pay has to be considered. And so in other words, the court can't just set bail in an amount that a person cannot afford unless they find that there are no other less restrictive alternative conditions of release that can reasonably assure that the person's appearance in court will occur or that the community's safety will still be preserved. So in that sense, it does allow money bail, but it narrowed the basis upon which money bail can be denied, and it required courts to assess safety, ability to pay, to put this into a place where people can get it. And so here's the quote from the Supreme Court. "Conditioning freedom solely on whether an arrestee can afford bail is unconstitutional. Liberty is the norm, and detention before trial or without trial is the carefully limited exception." Now, this case framed it through the Due Process Clause and equal protection as the basis for the decision, and it wasn't per se framed through the Eighth Amendment's money bail, but all roads lead to Rome, and it gets to the same basic place when you look at it that way. And here on our final slide before we hit our conclusions for the end of today's Curious Lawyer is some breaking news. From SCOTUS, Supreme Court of the United States, we have the question that's been raised in the 2022 term as to whether firing squads would amount to cruel and unusual punishment. And here the twist is that the petitioner wants a firing squad instead of a lethal injection. The case is Nance versus Ward from the Supreme Court. It's case number 21-439, and the decision came down June 23rd, 2022, right at the end of the term when the flurry of big decisions all came down. And the basic facts are as follows. Nance challenged the method of execution by way of a civil rights lawsuit, and his challenge was that receiving the intravenous introduction of drugs to stop his heart and then kill him was cruel and unusual because he had a particular kind of medical condition as it relates to his veins. And basically, is a factual matter, he posited that if the method of execution of the state were carried out, he would then suffer profound pain because it would explode his veins and the chemicals would seep into his body and cause collateral damage and pain, either before killing him or greatly delaying the process of death. And so he filed this lawsuit claiming that that method was unconstitutional. It was the only method allowed by state law in the state where he was convicted on the underlying crime. And so his argument was that he should receive the death penalty, but it should be by a firing squad, which was his choice. So this went to the district court and the 11th Circuit eventually, and both rejected his request on procedural grounds. Now, the procedural grounds that the court rejected it on were based on the idea that you cannot take these types of challenges to the method of execution via the civil rights laws, whether it be Section 1983 or the habeas laws. So in any event, that case then went up to the U.S. Supreme Court, and Mr. Nance's petition to the Supreme Court to be executed by a firing squad was indeed granted. The Supreme Court heard the case, and in a 5-4 decision, the Supreme Court reversed. And what the Supreme Court held is that the lower courts could consider the merits of whether Nance's alternative method should happen. Now, there was a dissent, of course, and in a 5-4 decision, we have our 4 dissenters, and this time Chief Justice Roberts was in the majority, making it 5-4, but our 4 dissenters argued that the only method available under state law is lethal injection, and that's the only method that then can be used. In other words, prisoners cannot bring these types of challenges to the method of execution via habeas 1983 or any other civil rights mechanism, and because then at root what they're challenging is the actual sentence as it's to be carried out under state law. But nonetheless, it was sent back. So the net of it is that the case is remanded now to the lower courts so they can assess it, and the state may well modify state law to allow it, or it may be cognized within the civil rights challenges of 1983 or habeas, and so it may turn out that Mr. Nance ultimately secures a firing squad. And just as a postscript note to you, 4 states allow firing squads as the method of execution currently, and that's Mississippi, South Carolina, Oklahoma, and Utah. This brings us to our conclusions today. We've seen, starting in terms of the historical experience with the founders at common law and in England, and then the founding of the Republic, the stressors, for example, that were present in terms of dealing with oppressive governments, the use of punishments to extort confessions out of people, the need to have a check on governmental power to do that, which gave birth to the Eighth Amendment's prohibition on cruel and unusual punishment. Now, we've seen that how has that played out for death penalty? There's been a bit of a ping pong in the 1970s on the availability of the death penalty, but now, yes, it is the law of the land that the death penalty doesn't violate the Eighth Amendment if it's used in certain circumstances for certain crimes and for certain kinds of people. And so we saw those cases dealing with the mentally ill and the availability of the death penalty, whether you can get the death penalty for rape versus murder and the like. So those cases have shaken out. We also saw Justice Blackmun's famous last dissent after his lifetime as a justice of dealing with what he called the machinery of death and tinkering with it, and the real complexities and troubles that he perceived plague the death penalty system in terms of capriciousness and arbitrariness and unfairness as it sort of applies to different people of different racial, ethnic backgrounds. We also have seen the battle, really, that's played out over how you interpret the Eighth Amendment. There's the originalist approach of conservative-leaning justices. There's the evolving standards approach adopted by left-leaning jurists. And the evolving standards approach has won out the day as of at least the last sort of half century or so, more than a century, as we saw some of those earlier U.S. Supreme Court cases. But we may have real changes on the horizon with the new makeup on SCOTUS as we look at the tightening of standards that are used. And so I think the questions that will be raised, we're in 2022 and in later years, are really revolve around whether the current makeup of the Supreme Court will push to go back to a more originalist approach, and that will then have implications for how all of these cases have played out in terms of death penalty, the scope of it, 3 strikes laws, broadening scopes of that perhaps or not, conditions of confinement, other types of punishments that could be at issue. And so it's a fascinating set of changes on the horizon for you, the curious lawyer, so stay tuned. There may be an Eighth Amendment Part 2 in the coming years as we see how the Supreme Court, once it gets its hands on the Eighth Amendment, what it starts doing more. We also saw solitary confinement as a massive issue, which is now on the horizon in a circuit split situation to really look at that case of whether 26 years of being held in solitary confinement with the attendant and mental health problems that it drives and suicide ideations that it drives for that petitioner, whether the Supreme Court will take it and what it will do in that case with him. And we saw bail standards, as bail can be required, but at least as the California Supreme Court has held, using the Due Process Clause, you have to take account of financial ability to pay. Otherwise, if courts are not considering financial ability to pay, it's unconstitutional. And those holdings probably are a harbinger of what's to come in other states as the bail issue is litigated more and more around the country, and as questions are raised more and more about the constitutionality of bail statutes, either within the Due Process Clause, Equal Protection Clause, or, for purposes of you today, the Eighth Amendment. So thank you very much for watching this program. Go catch our other Bill of Rights programs here at The Curious Lawyer, where you can learn all about the first 10 amendments to the U.S. Constitution. You can show up at cocktail parties and be the most educated person. Thank you.